It will be set first for every trial docket hereafter.
For criminal defense, if you never go to trial, you can't lose. You end up realizing some clients have a lot of evidence that's going to be hard to overcome. As long as they don't get convicted, they're not going to prison. That's a strategy. Judge John Stevens.
In 2021, Billy Woolley was indicted with 4 felony charges. His victims have been waiting for their day in court since then. Over 6 months ago, Judge Stevens said that our case should be specially set and move forward with no further delays. And yet there have been nothing but delays ever since. And each delay is seemingly more frustrating than the last, because each one seems more preventable. Here is what has transpired in our case, since it was first specially set.
August 5, 2024.
For the first time since 2021, the state was so sure the trial would be moving forward, pre-trial meetings were held with the victims. We tuned in for the docket hearing, with the near certainty that we would be flying to Texas that week.
We also have some witnesses as far as 404B and punishment.
404B evidence is prior bad acts.
That we'll have to fly in, they won't be able to be here until probably Wednesday. Yes, sir.
Mr. Macon is aware of what your proposed 404B evidence.
Yes, sir. I gave him notice of it.
Yeah, Friday afternoon, no,
I gave you one a long time before, about a year or two ago. There's a
the others, first part.
The first part, the second part is.
Yeah.
I did give you some stuff Friday, Judge, that I just discovered riding through witness that I did not know I had. So
ultimately, rather than moving forward, the trial was reset because of the recently discovered evidence. That's something I will discuss after the trial. Judge Stevens specially set the trial for November 18, 2024.
October 7, 2024.
Waiting for trial up to this point had been difficult, but tolerable because Mr. Woolley had been in jail.
Mr. Woolley had been incarcerated for over a year because, after posting his initial bond in 2021, he was indicted with an unrelated felony. His bonds were raised to $100K per charge, and he was taken back into custody. With his reputation as a bond skip, he had to come up with the cash up front. After 565 days of being unable to come up with the funds, he suddenly posted $400K cash. Coincidentally, or not, his mother's pottery shop had mysteriously caught fire a few months prior. No cause was ever identified. But with his reputation for insurance scams, I have my suspicions.
October 27, 2024.
After an emergency hearing to ensure his bond conditions included a GPS tracker, the upcoming specially set trial date was discussed.
The other thing I want to deal with is this trial date. We have a trial date coming up?
I think 11 and 18.
November 18th.
November 18th. How, I'd like to move forward on that. Any reason not to?
Mr. Eckert brought up that we do have an older case, it's a child case, sexual assault case that was set in that time, but we'll be glad to try on that day.
Well, that by rule of law, it takes precedence.
Remember what Judge just said for later. The other case of child SA takes precedence by law, because it's older.
That case is going to have to be tried first before this one. But I want this one tried.
How about your discussion?
Immediately after that one. At the next trial.
Judge, you have December 2nd and December 9th as trial dates for the finishing out the year.
It'll be tried one of those days. This will be specially set.
Yes, sir. Just tell me what forms.
Seems like the 9th would be.
Most likely.
Yes, sir.
All right. It's locked in on radar.
November 18, 2024.
I was informed that, despite defense counsel agreeing to appear for the specially set trial date of December 9th, he provided documentation from another court saying he had to appear there instead. We were reset, once again, a special setting for February 24th, 2025.
February 24th, 2025.
Just before this hearing, we were informed we wouldn't be moving forward. Defense counsel had, yet again, provided documentation from another court.
Billy Woolley. Mr. Laird, this Woolley case is languished way too long.
Yes, sir.
I agree. Way too long. Yeah. And I keep getting these motions, and this is 3 years, filed in 21. I keep getting these motions. Counsel will be in trial in orange. Is Mr. Macon here? So he's not able to explain himself, but I don't like that.
We showed you the protective order he had because they had a specially set case.
A protective order. I love it.
But we like,
if everybody put protective orders out, what a wonderful world we would be, right?
Yes, sir. My witnesses are available. We'd like to try this as soon as possible.
Okay, when's the next trial docket? It will be set first for every trial docket hereafter. All right, next week.
Just so I didn't follow up with it,
Okay.
but I can
You can reset one more week. Okay. I'll get a resettings for Which one are we going to go on, please, on that one? 37528.
Yes, the victim is pregnant and not able to have less than 39 pounds.
Mr. Woolley, tell me to get a reset.
As angry as we were that defense counsel had blown off our case again, we were encouraged by the fact that Judge said it would be set first priority on every docket from hereafter until we were able to proceed. My daughter, the victim in the indecency with a child case, who is now an adult, will be having a daughter of her own in August. So it is critical that we are able to finish this trial before May, when she reaches her 3rd trimester. I will not put my daughter's daughter in danger by going through the stress of a flight and a trial in her later pregnancy.
May 3rd, 2025.
Monday morning, I tuned in to watch the docket hearing. Our bags were packed. We knew this would be the day we would get the call. Our case was the oldest on the docket by over 400 days and said, "Do not reset." The hearing started off promising.
Number 1 is Woolley. Number 2 is Ford, in the event that happens to follow through. All right, so I have Billy Woolley 1, Joshua Sport is 2.
They went through the rest of the docket, trying to send lesser offenses to another courtroom. They had defense attorneys ready to defend, a judge ready to open their courtroom, but no prosecutors free.
Oh, hold on. What about Ellis F. Garcia? But then Mike Laird is handling Woolley, right? Okay, hang on. Can somebody pick Ellis F. Garcia? It's a criminal mission.
The plan proposal this weekend here was got this forward with this and I thought that the court was planning to Sarah. If you felt that it was fine, we can cover it.
I thought the request of all the parties was Billy Woolley. Come on up. Huh?
I think we're not happy with that right now.
Judge cut the audio to have a conference with our prosecutor and Woolley's defense. Essentially, our prosecutor had already agreed to let Mr. Macon defend a case very similar to ours that was 990 days old ahead of our 1,400-plus day old case. The rationale was that the other case had been specially set on the docket before our case was put on the docket. This was infuriating for many reasons, not the least of which is that the whole reason our case was reset was because Macon no-showed 2 of our special settings. And then, there's the matter of our case getting bumped from the November 18th docket, on which we had been specially set, because there was an older case on the docket, and by Judge's own words, the older case took precedence by law.
Fine. Court is going to correct itself here. Joshua Sport is number 1. Woolley is number 2. And if we don't get to Mr. Woolley in this one, we'll roll it over as number 1 the next.
So we were rolled to the next week, March 10th. But the day after this fiasco, we got word that another judge had already claimed Mr. Macon for her courtroom on Monday the 10th, which was today. Shocker. And next week, there's already a specially set case. Because apparently special settings mean something in every case but ours. So, we have landed on the March 24th docket as a special setting. I'll believe it when it happens. We have no word yet as to whether defense counsel has another case, or a wedding, or a funeral, or a flat tire, or a sick pet, or a doctor's note, or will be on vacation. We still don't know if we will be moving forward on March 24. And if we don't, we have 6 weeks until the victim will be unable to testify in a trial she's waited for, since so much longer than the near 4 years since he was indicted for these crimes.
Things play out. Witnesses end up passing, or they just get tired. That's why you have to keep pushing forward, because over time people go, "This has been so long I don't even want to deal with it anymore." So that's the most important thing a judge has to do, to push the cases forward. If we didn't assert and push, the Constitution would be kind of meaningless in a lot of cases.
I want to emphasize that I have a lot of respect for Judge Stevens. I do believe he has tried to move this case forward. However, it is past the point where it's reasonable for this to continue. I have reached out to him through the court coordinator and pled with him to ensure our case moves forward on March 24th. But at this point, I'll believe it when I'm sitting in the courtroom with all parties and a jury. I'm not entirely sure what I will do if he doesn't step in this time, but I do know that it will erode some of the trust I have in him. My trust in the Jefferson County, Texas justice system is already virtually non-existent. Judge Stevens is the last hope we have of getting this case to trial.